She's been living hand to mouth while he's been living a life of luxury.
His client was given a check for $9,000 and she got all of it. Okay. All of it. She cashed that check. She just bought a car. He pays for all of her insurance for her car, all of her health insurance, everything. So when he tells you that she only has $4,500, he's not telling you the truth. Good morning, Your Honor. First, I just want to point out my client, we take this matter very seriously. We're not just blowing this off. The way the order is and why we objected to it is my client has a net pay of about $760 a month. And if you look at the order, if the payment is made in the amount, there's no way that he can comply with the order, because the second part of the order says that if he doesn't continue to pay all the utilities and insurance, then it goes up to $3,300. So if you take the amount that's requested, that's $30,000 a year, and Mr. Gravis's net income is roughly
testimony of nearly $90,000 in 2022 versus claimed current net around $40,000. Judges will probe earnings history, timing and medical explanations through document reviews and forensic accounting. Proving voluntary income reduction can alter support calculations and contempt exposure.
$40,000 a year, so that it just does not compute. He's unable to make all of the payments that are required for insurance, for taxes, for mortgages, if it's $2,500. I know that we had a hearing on May 2nd and we're still waiting for a ruling on that. So what we would ask the court is to modify it so that it's an amount that he can make. And I'd also point out that following the March 2nd hearing, and I believe Mr. Koonman can attest to this, that a payment was made of $9,000 to his client as kind of an interim type of deal until we get a resolution. We also have mediation scheduled for June 27th. And hopefully we can get this matter resolved. And again, we could go through all of the issues, but I think we had a pretty good discussion and proofs put on the record on May 2nd. So we would ask the court to modify the order, or at least suspend it, given the payments that have been made, and the fact that in order for Mr. Gravis to comply with the order, on the one hand, to continue to make payments for her lodging and for taxes and for insurance, he cannot make the additional payment of $2,500 because there simply isn't enough money after deductions on the account to pay $2,500, Your Honor. So that's what the situation is.
Okay, thank you. Mr. Koonman?
Yes, thank you, Your Honor. Well, I think if the court looks at the order that was entered on March 13th, as Ms. Mullen stated, it says specifically under paragraph 3, this order continues until death of the payee or until the earliest of the following events, upon entry of the judgment of divorce or order of the court modifying or terminating the order. That's the plain language of the order. It doesn't say if the plaintiff objects to the order or if there's a pending objection. So this specious argument that, well, we've objected to it and therefore we don't have to pay anything under it, holds absolutely no water. They are blowing off the order. They are in direct violation of the court's orders. And as a direct result, my client has been living without any support. We filed this motion for temporary support in January. There's been $0 paid on the support order that was entered in March 13th. I can't speak to Mr. Sven Gross's math about the $33,000 a year because I don't know what numbers he's using, but I can say that when we had the evidentiary hearing on May 2nd, there was testimony on the record that he had earned almost $90,000 in the year of 2022, that he had intentionally reduced his income upon the filing of the complaint in this matter, and that he was intentionally overpaying the mortgage on the marital home by hundreds of dollars a month. That he could easily just have made the minimum payment on the mortgage and sent that extra money to my client pending this show cause hearing or pending a determination. But instead, there's been $0 paid. And with respect to the $9,000 insurance, if the court reviews the order with respect to that insurance check, one half goes to my client and the other half is held in escrow. But that's irrespective to the point before the court today, because the case law is quite clear. You should not have to dissipate the marital estate in lieu of spousal support. That's not how it works. She shouldn't have to use that $4,500 that she received in order to offset the spousal support. There's no authority to support that position. So our request before the court today is that the court
The request for civil contempt, $12,500 arrears, daily $100 fines, and $250 monthly penalties is severe. Courts weigh coercion against ability to pay. Excessive penalties risk destroying the marital estate, undermining eventual division. Is punishment or pragmatic resolution the better path here?
find the plaintiff in contempt, indirect civil contempt of the order, that he be immediately ordered to pay the arrearages of $12,500, that he be fined $100 per day that he fails to pay that arrearage amount, and that they impose a civil penalty of $250 per month since March 13th for directly thumbing his nose at the support order to the direct detriment of my client. I could go into detail about the life and the quality of life she's been living, but I don't think it's relevant. But to sum it up, she's been living hand to mouth while he's been living a life of luxury. Thank you.
Yes, Mr. Van Gross.
Well, you know what? As far as the conclusions that Mr. Koopman has basically stated, they're not true. There's no evidence showing that he's voluntarily reduced income or anything like that. And further, Mr. Koopman is not being truthful with the court because his client was given a check for $9,000 and she got all of it. Okay, all of it. She cashed that check. So when he tells you that she only has $4,500, he's not telling you the truth. So this was a discussion. Mr. Koopman sat in my office and we signed the check and he handed it to him the day of the hearing that we had. So he's lying to the court. And I don't know why he would do that, because there's no intent whatsoever by Mr. Gravis to deprive anybody of anything. This is a woman who left the marital home 4 years ago and has been living on her own. And all of these allegations that Mr. Koopman makes about hand to mouth, all of these, there's not been one shred of evidence put before the court to support any of that other than just blanket statements. And what Mr. Koopman says is not evidence. So it's not thumbing the nose. Our understanding is, and again, a direct agreement with Mr. Koopman to give him the check so that we could move this matter forward and resolve it. Instead, he comes in here and makes all these false statements and accusations. It's egregious. And then to ask to fine this man, so there's no way. In fact, he just said you should not have to dissipate assets because of spousal support. That's exactly what he's asking. The friend of the court is asking to do, and what Mr. Koopman is doing that because he cannot make the payments for the house that he pays for that she lives in. To say she's living hand to mouth, it's just not true. She has lodging and everything. She supported herself for 4 years. And now suddenly there's all these things going on and there's never been any evidence of it except what Mr. Koopman says. And that's not evidence.
I've got to stand up for myself.
Mr. Koopman, you'll have your turn. Go ahead, Mr. Van Gross.
We sat in my office and we said, look, here's $9,000 to get you by till we can work this out. He knows what the situation, he makes accusations about what my client is living some life of luxury. He is not. He is paying for everything for this woman. And the friend of the court order is wrong. That's why we objected to it. That's why we had a hearing to resolve it so that we can get some rationality. Again, if you look at the friend of the court order, it says somehow that she has all these medical bills. There's never been one bill submitted to the court. Even on May 2nd, there's never been one bit of evidence that she suffers from any injury. For all we know, this is a drug issue. She's lived on her own and traveling back and forth. She just bought a car. He pays for all of her insurance for her car.
Defense claims the $9,000 payment was handed over and cashed, directly challenging destitution claims. Documentary evidence, escrow receipts, bank records, and signed stipulations will be decisive. Small service or filing gaps later argued could swing credibility in court. What document would convince you?
Her health insurance, everything. And if the court imposes the draconian measures which Mr. Koopman recommends, there will not be a house. There will not be a marital estate. There will not be any money to give her when we divide what is left. Again, this party's been separated for 4 years and she's been living on her own. So the accusations that he makes are just completely false and frankly out of line given what has gone on to this point. I just don't know why he's doing that, considering he sat in my office and we talked to each other about this, and they managed to get us to agree to give them this money on the representation that this would be sufficient to get us to mediation. And so now he's just making up all these things and attacking my client, and it's really disheartening and unfortunate, because it's not necessary. There's nobody here trying to hurt anybody. What we're trying to do is get a case solved and allow my client to continue to live and continue to keep the marital estate afloat. Well, this woman, God only knows what she's doing. The court saw what we're dealing with here, and again, gave her $9,000 a month ago. So to make these accusations that somehow we're thumbing the nose at anything, when you go to make the deductions for this, there is no way that you can just say, well, there's only $500 left, but there's no way to do that. So what we're asking is the court to modify this to a reasonable amount, maybe $500 a month, in light of the fact that she has received $9,000, and so that we can get this thing done without having. We can't sell the cottage because we're under order not to sell it. Can't stop paying the insurance on the cottage because he's under order to continue to pay it. Can't stop paying the taxes because that would dissipate the estate and violate the order, and then cause it to go up to $3,300 a month. So basically what we're asking for is a rational order that, makes her at least provide some support for the allegations that she makes about medical costs and, $1,000 a month for food. It just doesn't make any sense. And what we're trying to do is get this matter resolved and not escalate it the way Mr. Kuhnman does with false accusations. So that's all I have to say, Your Honor.
Thank you, Mr. Kuhnman.
Absolutely outlandish. To call me a liar on the record, to say that I lied about this check when the order that was entered by the court specifically says, this is the February 16th order, 2023, the plaintiff agrees to immediately sign the insurance check issued for the lost engagement ring. Defendant agrees to place half of the proceeds of the insurance check into escrow until the court issues a determination. That's exactly what I said. She had access to half of it. The other half goes into escrow. To call me a liar on the record and impugn my reputation and say that I'm misrepresenting that order to the court is absolutely ridiculous. Secondly, with respect to my conclusions of law, that was the testimony of the plaintiff. His own words said that he reduced his income in 2023 because he was having health issues and was no longer able to work the hours that he had worked in 2022. So to call that a lie is absolutely ridiculous as well. The shoe needs to, well, let me just say this. I can tell from Mr. Svengross's advocacy that he has not seen the recommendation of the referee, because I just got it this morning. Apparently it was issued on May 15th. And our office never received a copy of it. And I can tell by his advocacy that he hasn't received a copy of it either. In preparation for today's hearing, I had my secretary contact the court, and it was just delivered to me a few moments ago. I think.
Wow. Ms. Mullen, did you know?
I do not have a copy of that order. I'm looking up the S400 right now.
Okay, Mr. Vengros, have you received a copy of the referee recommendation in order yet?
I have not.
Okay, because that was filed with the court on May 18th.
Okay, well that probably would have solved a lot of issues in advance.
And it was signed by Judge Hamlin on May 18th. Unfortunately, I'm looking at the certificate of service, and it is blank. So for some reason, after I signed it and Judge signed it, nobody ever, and after it was filed with the court clerk, nobody ever served it on the parties.
Well, we would
That is unfortunate.
request the opportunity for the court to amend that so we would have the right to at least enter some objections, because apparently that would mean that the objection period has passed.
Well, that would be unfair.
Yeah.
So what I will do is I will set a new objection deadline. The 21-day deadline starts from today.
Okay. Thank you, Your Honor. And given my understanding of it is that the recommended monthly amount is $700.
That's correct.
We'll do 700. Can you do it? We would agree to that, Your Honor.
And I made it retroactive to the date of the original support order.
Okay, and certainly my understanding, and again, I'll apologize to Mr. Kuhnman, because my understanding from our meeting when here was that she would get the entire check, not that any would be escrowed. And if it has been escrowed, feel free to send me evidence that it's been escrowed, but certainly we would request, I mean, that she can have the whole thing and that, you know, it's retroactive to February, and hopefully we could agree that he would get credit for that amount, or at least up to the portion that I think we could agree would be his share of that, or however we want to do it. We have mediation on the 27th, and this should go a long way to resolving that.
Here's what I'm going to do. I'm going to let counsel resolve the whether there was a stipulation and order entered on February 17th addressing the insurance proceeds. I'm going to let counsel just address that off the record. Do with that what you will. And Ms. Mullen, in the order today, please indicate that the deadline for objection to the referee recommendation and order entered on May 17th will now be, do some quick math here. The objection deadline on that referee recommendation and order is now going to be July 6th. July 6th. And this show cause hearing is going to be adjourned for good cause shown.
Okay, and the only thing that I would request, I don't know if I would go through Ms. Mullen or through the friend of the court, that if we could get an updated amount that would be due from February 1st and have that sent over to me, and we can make sure that we get it resolved one way or another.
I printed a copy of the order, so we will make the adjustments in with our accounting department, and then we can send a printout to you.
Dispute centers on whether insurance proceeds were handled per order, if income reduction was voluntary or medical, and whether contempt sanctions are proportional. Court set an objection deadline and adjusted accounting. Mediation may resolve this. If this shocked you, like, comment, and subscribe.